Jack? Where's Jack? Where is he? Jack, I want to see you. Great job, Jack. Thank you. What a job you do. You know, we have an incredible thing. We're always talking about the fake news and the bad, but we have guys, and these are the guys who should be getting Pulitzers.
All right, Jack Posobiec, we are back here, Human Events Daily, and I got to tell you, folks, here on the East Coast, cold weather, you know, we're saying it's going to be here, but it's kind of already here. And you know what I realized the other day? I'm just going to have to say it. If the power goes out when it's really cold, I have no way to keep myself and my family warm. Isn't that crazy? We could actually freeze. But then I heard about the Vesta off-grid space heater from our friends over at My Patriot Supply. Now, this is a space heater that doesn't use electricity. It runs on something called canned heat, which is an indoor safe fuel. And what's great is that with the Vesta stashed in the Poso closet, I know that my family will keep warm no matter what. And it doubles as a stove to boil water or cook food, which is pretty cool, honestly. Now, the best part is you can get a Vesta and a bunch of other free gifts when you order the Winter Prep Special from My Patriot Supply. Just go to mypatriotsupply.com/Jack to see everything included. This offer won't last long, and neither will the nice weather. So go to mypatriotsupply.com/Jack today. That's mypatriotsupply.com/Jack, mypatriotsupply.com/Jack. Folks, I said we were going to have it during the show, and we do have it. This letter that is now in draft form is about to be published, but we've got a copy of it that I want to show here right for you. humanevents.com. So Human Events Media Group, that's the official name of our company, is going to be publishing this open letter to the Honorable Tony F. Graff Jr. of the 4th District Court of Utah County, State of Utah. And it states, Human Events Media Group, a national news organization committed to transparent and accountable reporting, respectfully urges this court to deny any motion to prohibit video, photographic, or live stream coverage of pretrial and trial proceedings in the capital prosecution of Tyler James Robinson for the murder of conservative activist and leader Charlie Kirk. Such a ban would violate U.S. law, U.S. Supreme Court precedent, First Amendment protections, and the public's fundamental right of access to judicial proceedings. And now we've got all the citations there, but I wanted to dig in on two specific points before we bring our guest in here. And this is Utah Code of Judicial Administration Rule 4-401.01. And here's what's really interesting. It states that in Utah there is a presumption that electronic media coverage by a news reporter shall be permitted in public proceedings where the predominant purpose of the electronic media coverage request is journalism or dissemination of news to the public, the law states. A court may decline to permit cameras if the court determines, quote, there is a reasonable likelihood that media coverage will prejudice the right of the parties to a fair proceeding. So here's the idea that the presumption is already there under Utah law. Now, this is very expansive compared to other states that don't necessarily have this. And so restricting camera access, restricting live streaming, obviously would be a huge problem. And pretrial publicity alone does not justify camera bans. We covered that in this. We're going to publish this all at humanevents.com. And here's a piece that I wanted to put in. In Section 4, we wrote, banning cameras would amplify misinformation, not reduce it. In the absence of official courtroom footage, speculative secondary content on YouTube or AI-generated reenactments, partisan edits would fill the void. This would stand to increase, not decrease, prejudicial distortion. Live, unedited coverage is the most reliable antidote to misinformation, allowing the public to see proceedings as they occur, not as filtered through third-party narratives. And so this is all going to go up at humanevents.com. We're going to be delivering this to the court very soon. It's really simple. Look, I want everyone to have all of the evidence available. I want everyone to ask for evidence. I want people to be skeptical. I want people to ask questions and push for it. But what I don't want are bans on cameras and bans on evidence that could be coming out. Joining with me to discuss this and other legal matters, Will Chamberlain of the Article 3 Project. Will, what's going on, man?
Good to be with you, Jack, as always.
So Will, I called you this morning with this crazy idea that we were going to throw together this letter, and we've put it together. What do you think about this question? Right there, and I kind of get where the judge is coming from, or I should say, not the judge, but the attorneys are coming from. So their argument is, well, if we allow all this public consumption, he's not going to be able to have a fair trial because this is going to prejudice the jury pool and perhaps create undue interest in the case. And therefore, that's why we should ban cameras. And you also, of course, hear this in federal court as well. What's a good response to that?
Well, I think that there's a fundamental presumption that these proceedings are open to the public, right? Courthouses are open; they can be reported on. People show up and report on them all the time, and there's a reason for that. Justice is supposed to be done in public so that we're confident that the system is transparent and operating as according to law. That's, I think, necessary here. There's an enormous public interest in this trial for obvious reasons. And therefore, there's also an enormous public interest in ensuring that the trial is conducted transparently and scrupulously in accordance with law. So I think that's part of the reason why these proceedings should be public. And the public is right to be interested in this. This was the most high-profile assassination of an American in a very, very long time, probably since Kennedy, actually, in terms of a successful assassination. So it's something we should have the right to see.
Yeah, and it's really as simple as that to me. And look, these are always done in public, and that's part of our tradition in terms of the public court system. If it is public justice, yes, it is meant to be done in public. And by the way, for folks who don't know, if you ever, and I've covered a number of trials, D.C. area, I've covered trials in Virginia, you can just go. You can literally just go. And there are members of the public who just show up. And this is part of the point. And obviously there's space restrictions and physical limitations, but there will be overflow rooms if there are cases. There are media rooms if you're credentialed media, et cetera. All of this is done from the point of saying that if this person is to face whatever judgment they receive, and in this case, we are talking about the highest possible judgment in the entire world, that yes, actually it should be done in public, or else it's going to, and Will, I wanted to ask your question or get your sense on the other part is if you turn those cameras off in today's society, which is driven with or riven with, AI recreations and all sorts of just anything that anyone can do, I really think it's going to create a much worse environment for the trial.
Yeah, so I think a good comparison would be, what went on in the Chauvin trial and the Rittenhouse trials, where you had public live streaming and everybody was able to watch and critique it. In general, I think the judges in both of those cases did really well. If you actually look back and think, I don't necessarily approve, I don't like the outcome of the Chauvin case. I think Chauvin was innocent, but I don't think the judge did anything obviously wrong in terms of the way he was handling evidence, at least nothing that comes to mind. And I certainly think the judge in the Rittenhouse case did a great job. So compare that to how the judges conducted themselves in the state court trials of President Trump, both in the civil matter involving his organization that Letitia James brought and in the criminal trial for the false statements. I think that those judges, both of them, were wildly out of pocket. And I think part of the reason they were able to behave so out of pocket is because they didn't allow the proceedings to be live streamed and their decisions to be critiqued so aggressively.
And another one, by the way, recently, to take politics out of it in a sense, is the Brian Kohberger trial, which took place up in Idaho, the murder of those 4 sorority girls. This was a case that generated enormous public interest. There was a huge amount of publicity surrounding it, and yet there was no problem whatsoever with people being able to have access to that case, and it didn't affect the outcome of the case one way or the other.
Yeah. I think what's the big fear? What are you trying to protect with any sort of limitation on publicity or limitation on the ability of people to describe what's happening in the courtroom? Well, you're trying to protect the integrity of the jury. And you're trying to protect the extent to which the jury is considering evidence that's not been admitted into the record. But whether or not you live stream trials, it really doesn't have that much of an effect on that. Either the jury is going to pay attention to your instructions not to consume outside media about the case, or they're not. And if they do consume outside media about the case, they're going to get at least some sort of bastardized version of the internal reporting. I mean, if they might as well get exactly what they, rather than speculating or getting secondhand information, it doesn't really improve the situation if they're getting, or make it worse if they're getting the firsthand information. So the real question is, can you prevent jurors from consuming outside media about the trial as it's ongoing so that they're only considering the evidence that's been admitted? that problem just isn't implicated by live streaming.
Yeah, and there's a really, I believe this is from Richmond Newspapers v. Virginia, 1980. People in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. So, it's the explicit guaranteed right to speak and to publish concerning what takes place at a trial would lose much meaning if access to observe the trial could be foreclosed arbitrarily. And they're just really, taking that idea of a public trial and broadening it out to, and again, this would be the television age or new media. But again, the principle is something that has been around for hundreds of years, if not thousands of years, going back to even ancient Rome itself. A public trial to be held in public. Be right back. Jack Posobiec, Will Chamberlain, Human Events Daily.